You're listening to Compliance Insights, a podcast by Mnemonic. We discuss all things related to compliance with environmental, health and safety, and quality rules. I'm Una Jefferson. China is trying to improve enforcement of its environmental laws, and part of this effort has involved allowing NGOs and public prosecutors to bring public interest cases against polluting companies, as well as local governments who fail to stop them. To help develop their environmental courts and train environmental judges, the Supreme People's Court of China has partnered with Client Earth, an environmental law NGO with a long history of successfully suing governments over unenforced environmental laws. My guest today is Dimitri de Boer, who heads Client Earth's China program. So, Dimitri de Boer, hello, thank you for coming on.
Hi, Una.
To start off, why has Client Earth China decided to prioritize this initiative of helping to build up China's environmental courts?
Right. Well, so Client Earth is a fairly young organization. We're about 10 years old now, and it really started in Europe. And in Europe, unlike the United States, there were generally very few public interest lawyers working in the environment, and so it's kind of the first organization that really prioritized environmental public interest litigation. Taking governments to court over their failure to achieve air quality objectives and other environmental objectives. And so Client Earth, interestingly, came to China just about in 2015. And right at that time, China was about to, open up public interest litigation in China. And so that really was an amazing opportunity because, here was a young organization that was doing this across a number of jurisdictions in Europe. And I was working in China at the time with the Ministry of Environment and also with the Supreme Court. And they were extremely interested in this experience and very eager to have Client Earth come to China and, help the Chinese government and Chinese NGOs to build up this space.
A lot of the groundwork for public interest environmental litigation in China was laid by reforms that were made in 2013, 2014, 2015. How's it going so far, a few years in terms of, the number of cases brought, but also the quality of decisions that have been made so far?
Mm-hmm. Well, public interest litigation in China today can be split into two main categories. One is the cases that are brought by NGOs, and one is the type that's being brought by prosecutors, state prosecutors. And NGOs can bring cases against polluters or companies, but not against government. And the prosecutors can bring cases against both government and companies, but they tend to focus on government. And the number of cases from NGOs has been sort of steady at around 80 to 100 every year. And the number of cases from prosecutors has been much larger, like in the thousands, exceeding 10,000. So, that's not to say that the NGO cases are not developing very well. I mean, I think in any jurisdiction, 100 environmental public interest cases being brought by NGOs is actually a very impressive number. Europe doesn't see that many cases like this, for example.
Do you have a sense so far of what the relative strengths and weaknesses of NGOs as opposed to government prosecutors for environmental public interest litigation have been in China?
Yeah, so I guess the perception is that NGOs are more independent from government and therefore able to bring cases that might be more politically complicated. Whereas prosecutors are a bit more restrained. They're more closely affiliated with, in China, they belong under the judiciary arm. So they're very closely affiliated with the courts. But generally, the perception is that courts and the judiciary in China are still quite closely affiliated with government. So, when that system for the public interest cases being brought by prosecutors was first launched, many legal experts were very critical, questioning the viability of that. But I think what experience has shown is that the prosecutors do actually come and bring very exciting and interesting cases, and that's probably got to do with the fact that they have a fairly strong line reporting system. So they are, let's say, a higher level prosecutor will say, okay, something has to happen in this particular city or whatever. There's a problem here, and then the lower level prosecutor will take orders from their superior prosecutor to go and bring that case, even though that might be still quite problematic for them at the local level, but they just have to do that. And NGOs in China are, it's still a very growing space. It's a much earlier phase of development than perhaps the United States or Europe. So there are not that many NGOs in China that are that have the skills and the resources to bring good public interest environmental cases. You know, you need to have a fairly strong financial, but also skills basis. You know, people in your organization have to understand how to do that, and then of course there's still the political problems. I mean, if you bring a case against a very strong defendant, then that, you know, for a smaller NGO, that might be too risky. So they'll also think twice before they bring a complicated case.
Right. Have you seen any cases so far where the decisions made by environmental courts in China have differed from the environmental policy line of the government? I should say the central government.
Yeah. Well, that's an interesting question. I guess not really, but the central government's line on environment has been generally very gung-ho. So, you know, going for strong environmental action. If anything, I think there are still quite a lot of areas where the central government has a position, like climate change, for example. The central government says climate change is a major priority. You know, fully backs the Paris Agreement, but then within China, you don't see any climate change related public interest cases yet.
Why is that, do you think?
Well, it's difficult. I mean, there's no climate change law in China currently, but in other jurisdictions, what you'll see is that NGOs get pretty creative and use corporate law or air pollution, air law, for example, or energy law to try and bring cases that actually are climate cases. In China, there's one example of such a case, but it's still pending. There's an NGO that brought a case against the grid in Gansu province. The state grid in Gansu province failed to prioritize renewable energy against coal energy, and it's their legal duty to buy all renewable energy, but they haven't done that. Interesting. Yeah.
I'd like to talk a bit more about that kind of difference you mentioned between the gung-ho line on environmental problems taken by the central government, and then a lot of the public interest litigation so far has been forcing local governments to enforce previously unenforced environmental laws. Mm-hmm. So why is there this difference in attitude towards environmental laws between the central and local level?
Well, at the central level, you know, the Ministry of Environment, for example, it's their mandate to fix these environmental problems. But on a local level, local governments, mayors, for example, they need to consider all kinds of things like economic development or local employment and other social issues. But generally, also, it's easier for local government officials to be slightly captured by local industry because, you know, on a local level, those are perhaps the most important players. And so they have a tendency to make decisions that may or may not favor the environment.
And Client Earth China, you've been helping the Supreme People's Court of China to organize trainings for environmental judges. There were several trainings held last summer. So can you give me a sense of what the content of these trainings has been?
Well, generally, I mean, we focus on the topics that the Supreme Court is interested in, but we've had public interest cases, for example. So these environmental judges receive all kinds of cases, not just those brought by NGOs or by prosecutors. So that's one type of training that we've done. We've also looked at climate change, climate cases specifically. So looking at other jurisdictions, what kind of climate cases were brought. Interestingly, for that training, China's climate envoy, Xie Zhenhua, who was the main negotiator of the Paris Agreement, was brought in and spoke to these hundreds of environmental judges in China to explain to them that climate change is a threat to China, and it's not just something that China wants to act on because of international pressure.
So based on those types of conversations, do you think that there will be more climate change cases being brought in China coming up?
Yeah, I expect there will be some. It's also possible that there will be a climate change law in China. Responsibility for climate action has moved from one government ministry to the Ministry of Environment, and the Ministry of Environment has a bit more of a legal focus on solving problems. So it's very likely that we'll see a climate change law, and more generally, information disclosure and public participation in climate action in China.
China's made the choice to develop kind of specialized environmental courts. And there are several other countries in the world that do this. I know they have some in Australia and some American states, some in India, but they're fairly new. And how does a specialized environmental court compare to trying environmental problems in general courts? Are there benefits and drawbacks to each approach, or do you think specialized environmental courts are better?
My personal take on this is that it's a good thing to have environmental courts, because environmental disputes tend to be fairly technically complex, and just generally environmental knowledge. It's pretty complicated, ecosystems and things. It's easy for, let's say, a generalist judge to perhaps overlook a number of very important issues when trying in a case that relates to the environment. So, and of course, the defense, many countries, they say, okay, we don't want to have specialized environmental judges because we want all of our judges to be, to fully understand all of these issues. But I just don't think that's really a realistic goal. And what you're seeing in countries that do have environmental courts is those courts tend to make decisions which are much better for the environment. So I think if a country is very serious about protecting its environment, then it would do well to develop specialized environmental courts. China now has several hundred environmental courts at all levels, including the Supreme Court. And you're seeing that they're a very interesting force for the pushing for further environmental protection, especially through legal means. So they're also an important voice in government, and they do also perform, I would say, a broader role than just trying cases. For example, in China, they work on the interpretation of law. So very often laws in China are a little bit cryptic. It's more like a set of principles. But then when these actual cases come to court, a judge won't know how to interpret those principles and actually rule on it. And so the Supreme Court in China develops what are called judicial interpretations, which are legally binding documents that set out the procedures and the considerations that local judges should take into account when trying certain cases. So they actually do have a very important role to play here.
Do you have any future involvement with these environmental courts planned? Any future projects?
Yes, many. So every year we do a large training. So the National Environmental Judges Training in China, we jointly organize. And then we take the Supreme Court judges and also the High Court. That means that the provincial level top court judges overseas regularly to expose them to best international practices. We're jointly drafting manuals, like books, that judges can use as reference materials. And we're going to have, interestingly, later this year, a seminar with the Supreme Court on environmental adjudication for the Belt and Road Initiative. So how should environmental disputes in Belt and Road projects be resolved?
Could you talk a bit more about that?
Well, it's early days, but
okay.
Yeah, some of my thinking on this is that environmental governance of the Belt and Road Initiative needs to be strengthened. There are too many, let's say, environmentally destructive projects in the Belt and Road, or climate unfriendly projects. So there's too many coal-fired power plants, for example, and it's quite foreseeable that there will be a number of environmental disputes, related to new ports, highways, hydro dams, etc. So having some kind of a mechanism for international dispute resolution related to Belt and Road projects, I think, would be very useful, and it might also help to focus, investors and recipient countries on the need to take such issues into account from the outset.
Well, listen, we're unfortunately out of time, but this is really interesting stuff, and I appreciate your taking the time to talk to me about it.
Right. Okay. Well, it's definitely a pleasure, Una, and thank you for the interview.
Thank you for listening to Compliance Insights, a podcast by Mnemonic. We'll post a full transcript of this conversation on our website at mnemonic.com. That's NIMONIK.com. And if you have any questions, comments, or topics you'd like to hear discussed, please reach out. I would love to hear them. You can send me an email at ujefferson@mnemonic.com. And you can find us and subscribe wherever you get your podcasts or online at mnemonic.com.